Dear viewers, welcome to another episode of Editorial Analysis by Drishti IAS. In this program, we focus on important editorials from major newspapers such as The Hindu, The Indian Express, The Hindustan Times, Times of India, etc. for effective understanding of students. Now, through this program, we focus on three things. First, we try to link the editorial with that of the UPSC syllabus. Secondly, we try to understand what are the key points that are mentioned in the editorial. And lastly, and most importantly, we try to learn what are the key concepts, if any, that are mentioned in the editorial. Hope you like this new initiative of Drishti IAS. Dear viewers, feel free to give us your valuable and honest suggestions so that we can strive to do better each day. Thank you, and let us commence today's session of editorial analysis. For today, we have opted for the editorial from The Hindu titled For the Weakest. It was dated on 31st August 2020. The editorial technically talks about a judgment passed by the Supreme Court on an appeal raised by the state government on whether it can give preference to sub-categorization within the scheduled caste. Now, before we go to the editorial, let us try to link it with that of the UPSC syllabus. This judgment is more important from mains perspective. Where we can connect it with General Studies 2, wherein it talks about constitution, polity, social justice, and then further narrowing it down to Indian constitution, welfare schemes for vulnerable sections of the population, then mechanisms, laws, institutions, and bodies constituted for the protection and betterment of these vulnerable sections. Dear viewers, since this is a judgment, let us try to understand the context or the background on what led to this judgment. Now, the present case before the Supreme Court of India on which the judgment was passed was technically an appeal raised by the Punjab government against the Punjab and Haryana High Court, which had struck down a state law empowering the government to subclassify SC/STs for grant of quotas. Now, the Punjab government, out of the seats reserved for the scheduled caste, had further reserved 50% for the Balmikis and Mazhabi Sikhs. However, this had created an issue, and the High Court had passed a judgment which had struck down this circular of the Punjab government. Now, the High Court in this judgment had relied on the 2004 EVI Judgement of the Supreme Court for striking down the law. Now, what does the EVI Judgement say? Now, in EVI Judgement, a 5-judge bench had considered the validity of an Andhra law that had further divided the list of scheduled castes into 4 categories, that is A, B, C and D. Now, there was 15% reservation for scheduled castes in educational institutions and government jobs, and among this 15%, the then Andhra government decided to further categorize, that is 1% for group A, 7% for group B, 6% for group C and 1% for group D. However, the case was raised and it finally reached the Supreme Court, and the Supreme Court had declared that this law as unconstitutional in 2004, and it held that any further classification within the scheduled caste list notified by the President under Article 341 would amount to tinkering with the said notification. The Supreme Court had also called the presidential list as homogeneous and said only Parliament can exclude a caste or a part or a group of caste from this list. Further, it stated that subclassification would violate Article 14 of the Constitution, as it would tantamount to discrimination in reverse. Now, with this background and judgment in mind, let us go to the judgment that was passed on August 28. So now the 5-judge bench headed by Justice Arun Mishra, however, went in the opposite direction and affirmed the competence of the states to give preferential treatment to the weakest among the scheduled caste without depriving other castes of any benefit. The court has noted that the scheduled caste list contains many castes and cannot be treated as a homogeneous group. It also recognized the obligation of states to identify for preferential treatment those sections within the SC communities to whom reservation benefits had not trickled down and were in the same state of backwardness for decades. The 5-judge bench had disagreed with the formulation in the EV Chinnaya versus State of Andhra Pradesh 2004 that classifying scheduled castes into groups amount to tinkering with the presidential list. However, Since this is a five-judge bench and the EV judgment was also based on a five-judge bench, the current bench has asked the Chief Justice to put this judgment to a bigger bench and decide on the outcome. However, let us try to focus further on this judgment. Now, as per the editorial, there were also concerns with this issue. One, the editorial raises that there has been recent jurisprudence, or there has been recent notifications by the Supreme Court and the government that talks about viewing creamy layer concept, and they say that it should also be applied to SC/ST candidates too, thereby leading to exclusions. Now, the editorial states that given the increasing oppression and marginalization that Dalits continue to face in India, they've raised this question on whether this is actually the appropriate time to begin excluding some of them on the ground just because they are better off. So this is a question that has been raised very often. All right. And also there should be less concern about the creamy layer occupying post, and rather more focus should be on ensuring adequate representation to the most marginalized among Dalits. So this was the key points and the concerns raised in the editorial. So let's try to summarize what has happened so far. Now, the background, again, the Punjab and Haryana High Court had decided to strike down a law raised by Punjab government empowering the sub-classification of SCs or STs for the grant of quota. The High Court had struck down this law on the basis of EVI judgment of the Supreme Court. Now, the EVI judgment, what did it say? That classification within SC list as notified by the president would, amount to tinkering. That is any further classification within the SC list. And also the presidential list is a homogeneous, and sub-classification would tantamount to discrimination in reverse. However, this was raised, again with the Supreme Court. And what did the Supreme Court recently rule? The latest judgment states that states are competent enough to sub-classify and to give preferential treatment to weaker sections within the list. The SC list contains many castes and can definitely not be treated as homogeneous. However, the editorial has also raised concerns. What is it? Whether now is the appropriate time to exclude or prioritize some sections. We need to refocus on our priority for treating the oppressed classes, and rather the focus should be about ensuring adequate representation to the most marginalized among the communities. So with this, we have tried to understand what are the key points. We have also summarized it, and now we move to understanding what are the key concepts that has to be understood from the editorial. Now, of course, we begin with the constitutional provisions. Clause 4 of Article 15 and Clause 4 of Article 16 technically allows the government to make special provisions for reservation in admissions in higher academic places and appointments for those communities which are socially, educationally backward classes or are from scheduled castes or scheduled tribes and, in the opinion of the state, are not adequately represented in the services under the state. Also, Article 338 provides for the constitution of a National Commission for Scheduled Caste, which makes recommendations on the measures that should be taken by the center or the states for the SCs. Now, you might remember that we have discussed about the presidential list, or the Supreme Court or the High Court has raised this. So what is the presidential list? See, now the Constitution, while providing for special treatment of SCs and STs to achieve equality, it does not specify the caste or tribes that are to be called scheduled caste and scheduled tribes. This power is technically left to the central executive, that is the President of India. Now, as per Article 341, it empowers the President to notify the caste, race or tribes or parts or groups within caste, race or tribes that will be considered as scheduled caste in a state or a union territory. It can vary from state to state. For states, the President is also required to consult with the governor before issuing the notification. Now, Article 341, subsection 2, it states that Parliament can make a law to include or exclude any caste or tribe from this list. Article 342 provides a similar provision which has been made for scheduled tribes, and Article 342A also provides provisions for socially and educationally backward classes. Now, another concept that we have to focus is on the arguments on whether subcategorization is required or it is not required, and this is very important from mains perspective. Now, what are the arguments that support subcategorization? Now, as India is a welfare state, its obligation is to undertake the emancipation of the deprived section of the community and eradicate inequalities. Now, Of course, we know that evidence suggests that a few castes with access to material resources, land, cultural capital, and education have been cornering most of the benefits extended by reservations to SCs. That is, in terms of employment and admission to educational institutions. And this is a very wide and known fact. Now, with reservation treating the SCs as a homogeneous community, the social and economic inequalities within have only widened further. So, when the reservation creates inequalities within the reserved caste itself, then it is supposed to be taken care of by the state. Now, how does a state do it? Simply, it makes sub-classification. That is, within the quota, it makes more classification of communities and adopt a distributive justice method so that state resources do not concentrate in few hands and equal justice to all is provided. States like Andhra Pradesh, Tamil Nadu, Bihar, and Punjab have already introduced subcategories within the SC reservation in a bid to rectify the situation. However, there are also arguments against subcategorization. To begin with, see, now the special treatment given to SEs is due to the historical fact of untouchability with which they have suffered for a long time. They've been under a historical disadvantage. Therefore, the only argument that, a requirement of social or educational backwardness is enough to exclude them cannot be applied to scheduled castes and scheduled tribes. That is, one generation or two generations cannot mitigate the fact that they have historically suffered or have been in a disadvantaged position. Also, in 1976 case, the state of Kerala versus N.M. Thomas, the Supreme Court had clearly laid down that scheduled castes are not a caste, rather they are a class, and hence they are more homogeneous in identity. And of course, most important thing is the worrisome factor. That is, a lot of states use this subcategorization to change the proportion of reservation, which can be further misused to appease one vote bank or the other. So with this, we hope that you have also understood what are the key concepts in this issue and in this editorial. Now, let us try to understand this editorial from the UPSC examination perspective. As mentioned earlier, it is very important for mains perspective. Some of the questions that has been asked, this was in 2016, where the question was on two major legal initiatives. That is, what are the two major legal initiatives by the state since independence addressing discrimination against scheduled castes or scheduled tribes? In 150 words it was asked. Also, why are the tribals in India referred to as the scheduled tribes now indicate major provisions enshrined in the Constitution of India for their upliftment? Other than this, from this perspective, we can think of a question that Drishti has framed, wherein reservation in India is a system of affirmative action that provides representation for historically and currently disadvantaged groups in Indian society. Discuss this statement in the light of the recent judgment of Supreme Court on subcategorization of SC and ST. Dear viewers, feel free to write your answers in the comments below and we can discuss this further. With this, we end today's session of editorial analysis. Hope you have thoroughly enjoyed this session. Dear viewers, we are completely dependent on your suggestions and feedback so that we can improve and strive to do better every day. So until next time, stay safe. Thank you and all the best.